State has to.
Are there any additions or corrections?
Not from the defense, Your Honor.
Not from the state, Your Honor.
My inclination, if I'm going to follow this agreement, is possibly based on some of the statements of family members as well as probation, is special needs safety. There's obviously some thank you so much. There's obviously some drug history and abuse of several different things in that list, as well as some mental health issues that need to be taken care of. And I think to get started on this probation, if I'm inclined to go along with it, that's what I would be inclined to do. Do you want to?
Yeah, can I get a minute?
Yeah, visit with her about that, but that's based on the history, with same types of offenses. That's where I'm headed. So y'all can visit for a minute and then I'll take care of it, just so she knows what I'm talking about. Good morning, sir. You're Larry Fitzgerald Williams.
Yes.
And in cause number 25, DCCR 0985, Mr. Williams charged with capital murder. And then the other case is a motion to revoke probation that Mr. Johns represents him on in cause number 24, DCCR 1790. It's not a motion to revoke probation. I'm sorry. The other case is an aggravated assault causing serious bodily injury. And so, Mr. Cashin, obviously your case is the top one on that. What is your announcement?
We are not ready to proceed yet. We need to get all the information from the DA's office. We have to review some of the evidence that they have provided. We want some phone records. I'm going to get with ADA about some of the phone records, the forensics on his cell phone, the forensics on the phone of the decedent, and a couple other things that we have to do.
And do you have everything in your possession to turn over at this time that you know of, Mr. Smith?
As far as I know, they do.
Okay. If y'all will just get together and visit about that, if there's something that Mr. Cashin needs that you don't have, if you'll get with law enforcement, let's get everything. And then what I'm inclined to do, just based on upcoming holidays and things like that and resets, I'm inclined to give a longer reset, but I don't want y'all to wait till the last minute. If I do that, go ahead and get everything, visit. I'm going to do a reset to maybe that first week in January. That should give y'all plenty of time, hopefully on a case of this nature, to get more up to speed. And then I'd like an announcement if we can on that date.
That's kind of what I was expecting.
Okay, sounds good. Then we'll see you back then.
Thank you.
Thank you, sir. You're free to go. You can go back with the bailiff, sir.
Yes, Judge.
And Ms. Hill, in cause number 25, DCCR 0650, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of assault family violence by impeding breath or circulation, sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete this special needs safety program. That is intended to help you with everything that's going on in your life, any mental health treatment you need, as well as substance abuse treatment, so that when you get out, you'll be better equipped to be successful on this probation. And so if you do everything that you're supposed to on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back in here and you'll be looking at that 10-year sentence that you've already agreed to. Do you understand? Also, it's very important that you understand you can have no contact or communication with Cheryl Johnson. That's in person, that is electronically, through messages, or anything like that. Do you understand? And even if she gives you permission and says, oh, it's okay, I'm not giving you permission, and that's how that has to work. You understand? All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think if you
bond.
just let me review his criminal history, the decision will be very easy.
I've already know what I'm gonna do, but I'd be glad for you to do that as well.
Your Honor,
ahead.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
What is that?
This may be the defining moment of the hearing because the conversation has shifted away from a simple bond request and into something much larger: credibility, behavior, and future risk. The court isn't only looking at charges on paper anymore. The judge is openly weighing criminal history, missed court appearances, allegations involving jail conduct, and repeated interactions with law enforcement. Legally, bond decisions are not just about whether someone can pay. Judges can also consider public safety concerns, appearance history, and whether conditions are likely to be followed. That appears to be where the courtroom focus is moving right now. But here's the question. When repeated behavior patterns continue appearing in court records, at what point does rehabilitation stop outweighing risk? That balance can completely reshape outcomes in hearings like
I want to see what the bond is set at on the new case, 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. So Ms. Holmes, any,
So So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
Really? You're aware of that?
Yes, ma'am.
How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail?
No, ma'am.
This is ridiculous. These people are just going to work and trying to do their job. That's all.
Yes, ma'am.
You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. Do you think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient, and in that case I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device and you will be on house arrest. So if you make these three bonds.
At this point, the courtroom is about to split into three very different outcomes. One defendant is being offered a chance at rehabilitation through probation and treatment. Another is about to learn how quickly a bond hearing can turn into a harsh lesson about accountability. And a third is heading toward a lengthy prison sentence through a negotiated plea deal. Watch closely, because what happens next highlights one of the most important realities of the justice system. Judges aren't just looking at the charge in front of them evaluating patterns of behavior, personal history, and the likelihood that someone will follow the rules moving forward. Which factor do you think carries the most weight in decisions like these? The current offense, criminal history?
Bonds, you will be on house arrest.